bite-sized podcast published by the Meritas EMEA Employment Group. Periodically, members of our practice group get together to discuss interesting and topical cross-border issues. Meritas is a global alliance of leading independent law firms dedicated to helping clients access top-tier legal expertise from anywhere in the world. I'm Sam Murray Hines, and I'm an employment lawyer at the law firm Howard Kennedy in London. I also head up the Meritas EMEA Employment Group. Welcome to today's episode. Today, I'm joined by Hans Helwig from Graaf von Westphalen in Germany and Jet Baum from Lexens in the Netherlands. Both are employment lawyers. And our discussion today is on works councils. To set the scene, a works council is a formal body of elected employee representatives that engage with the management of an employer to discuss and consult on workplace matters. It's designed to promote employee participation, workplace democracy, and constructive dialogue between employees and management. Now, they're different from trade unions. With a trade union where statutory recognition is in place, the trade union represents workers in negotiations over three core matters, which are pay, hours, and holidays. Unions are governed by their own legislation and collective bargaining laws, whereas works councils are consultative, but still carry a lot of weight and impact on processes and transactions affecting employees and employers. Today, we're going to talk about works councils in the context of mergers and acquisitions. Hi, Annette. I was going to start with you, if that's okay. Could you just give us a bit of an introduction into how works councils operate in the Netherlands?
Yeah, sure. So works councils in the Netherlands are working on the basis of the Works Council Act. And every company in the Netherlands who employs 50 employees or more is obligated to install Works Council. And the Works Council in the Netherlands has several rights, including the right to render its advice on certain matters and the right to give their consent on other matters. It's an important part of Dutch employment law. I should notice that if you do not install a Works Council, whether it's obligated, there isn't really a sanction. So it's promoted, but if you request within the company several times in a couple of years whether there's interest in installing a works council and there isn't any, if you don't install it while you have 50 employees or more, then there is no punishment.
Okay, and Hans, welcome to the podcast as well. Can you just tell us if the position's different in Germany?
Yeah, thank you very much, Sam. In Germany, it's fairly similar. The only big difference I now hear from Aniet is actually that in Germany, there's no obligation by any company to actually install a works council or like motivate. It's founded, but it's purely to the up to the employees, to start the initiative to create a works council or form a works council. Beyond that, it's very similar to the Netherlands. I guess the Works Council has rights of information and also the right to advise. And the most powerful right is what we call co-determination. So they actually have to give their consent for certain, or with regard to certain topics.
Okay, so taking those points forward then, Hans, when you're looking at things in the context of a corporate transaction, what considerations does a seller need to have, for example, when they've got a works council?
Yeah, in case the target company, the seller has a works council in its company, then he must inform either the works council or if the target 100 employees. Usually, you have a so-called economic committee, which is a part of the works council. And this has to be informed by the seller in a timely and comprehensive manner with regard to the transaction and the effect of the transaction on its business. As the only prerequisite, one more prerequisite which we have is that the shares which are acquired must be at least 30% of the equity of the target company. Below 30%, there's no such right of information.
Okay. And yet, is the position different in the Netherlands, or it's sort of similar?
Well, it differs a little bit because in the Netherlands, if there is a change in control, whether it's fully or 10% or a certain percentage, in general, then the Works Council has the right to advise on the transaction, and the Works Council of the seller, and in some cases also the Works Council of the buyer. But the Works Council of the seller has the right to advise on the transaction and must be informed about it in a timely manner, so that the Works Council actually can be of influence on the ultimate decision whether to sell the shares or not. So that's a difference, I think.
It's quite interesting because where there aren't works councils already in place in the UK, obviously since Brexit, position has changed with requirements, but with trade unions or even just employees generally, the only right to get involved in a transaction if there's a sort of right engaged for collective consultation, or if there's a 2P transfer and there's that right to sort of information and consultation. So the operation of the Works Council is quite interesting to learn a bit more about it across different jurisdictions. So it sounds like Works Councils can impact on a transaction quite sort of severely. And I just wondered, Anjet, in the Netherlands, so do they have the power to veto a transaction? Can they hold things up? Does what they sort of say about the transaction, can it affect how it's structured?
Actually, they can, yeah, ultimately. I mean, I must say that if there aren't really any consequences for the employees, which is normally the case, if it's only a share transaction, right, then most of the times nothing happens. The shares are being transferred to another company, but the target company remains standalone and will continue its business as usual. And so if there aren't any direct consequences for the employees or the business, then it's not really likely that the Works Council will heavily object to it. So what happens is that the Works Council will be asked to render its advice. In the advice, it's a written advice normally, and then the company explains why the transaction is intended, what the upsides are, what the consequences are, that the Works Council should treat it confidentially, and what the timing of the process would be. And then the Works Council may have a lot of questions. What happens to the directors? What happens to finance? Are there any consequences for the employees? Will business change? Will there be a restructuring or a mass layoff, for example? And if that's not the case, they would most likely give a positive advice for the transaction. But if it doesn't, or the process hasn't been followed correctly, then the Works Council can go to the Enterprise Court of the Netherlands. And eventually, if the Enterprise Court deems that either the process wasn't followed correctly or the company couldn't reasonably decide to continue with the transaction, to actually stop it. But that's an extreme situation.
Okay, and Hans, the position in Germany in a sort of similar sense?
It's not as severe as it is in the Netherlands, as there's no right for the Works Council to actually stop a transaction, but the Works Council may seek an injunction with the employment court if it feels that either it has not been informed at all, or it has not been informed in a timely manner, and also not comprehensive enough. Those are basically the critical points. Or sometimes there is always one exception to the consultation procedure or procedure of information, is that the target company's management says we do not have to inform you in more detail than we did, because we have a strong interest of confidentiality and trade secrets. So if we have to be afraid that if we cannot be sure if we inform you that some of this information reaches people outside the company, because, let's say, in the past the Works Council has not always met its obligations with regard to confidentiality. So this is those are basically the issues you discuss in this process. If the management of the target company does not abide by the Works Council's rights at all, then they run the risk of getting an administrative fine up to 10,000 euros, which they also may be liable personally. liable for in person. So that's quite severe. Yeah, but they can, maybe the works council can put the process on hold, but they cannot stop it in total.
Yes, it sounds to me that it's really important when you're doing cross-border transactions to make sure that if there is a works council, at least checking if there are works councils involved and making sure that you get the right advice to make sure that timelines are considered and the structure generally of the deal. I'd be interested to hear a bit about the post-acquisition considerations as well, where there are works council. So obviously the transaction is the kind of thing that everyone's focused on, but there are issues arising out of transactions sometimes where a company might want to restructure, there might be redundancies or an attempt at harmonization. And I just wanted to understand how you've been advising clients to deal with those issues and at what point you get involved in advising them on those. And yet.
Well, that is quite often the case, right? And if you are already aware of the situation while you're planning the transaction itself, it would be recommended to include it in the original request for advice, right? So if you are not able to guarantee to the employees that nothing will change, then it could be sensible to immediately request the advice of the Works Council for the restructuring as well. And so in the Netherlands, the Works Council does not have any rights or entitlements regarding employment conditions, but it does in respect to 2P or harmonization in general or restructuring. So it could be, well, it is advisable to, if you're planning a transaction, to discuss the post-transaction issues with your lawyer or with your advisor to create some awareness whether it's sensible to immediately ask the Works Council for advice on that matters as well, or to separate it and to first start with the transaction, the actual transfer of shares or asset purchase, and afterwards move forward with the post-transaction issues. But it should be taken into account definitely before you start with the initial transaction.
And I'm assuming, Hans, the position is similar in Germany in terms of getting your ducks in a row.
Well, yeah, I mean, if you want to be, or first of all, I would like to add maybe one sentence we can add to the previous part, which is that we always strongly advise to also on the buyer side, to make sure that all the Works Council involvement and the rules related to it are abided by the seller, because otherwise, the whole transaction can be at least postponed, which most likely will not be in the interest of the buyer. So that is one interesting part.
Yeah,
in
it's basically the buyer and seller liaising together as well.
Yeah. But with regard to post-merger measures, we always, I mean, if you would do it by the book, it's like Annie had said for the Netherlands, but you don't want to do it by the book and inform the Works Council on the seller side already pre-closing about any potential restructuring or reorganization measures, because then the whole consultation procedure will be much more difficult, and the Works Council will most likely ask for details which you, in most cases, won't even be able to give already, because you may have an idea that either maybe you merge two companies, with the target company with another company you already have, or you say, okay, we're gonna we want to benefit from synergy effect, so that's why we reduce maybe we close one department, but in most cases they don't have the full plan yet, and so this would create like a never-ending consultation procedure, I assume. So we always advise to inform the Works Council on the deal, full stop, and then after the closing, then you look at reorganization measures if you want to plan those, and within those, the Works Council has a very strong right of co-determination, and you have to negotiate a so-called balance of interest, and maybe even, if redundancies are involved, a social plan, and that can take many months if you don't quickly agree on the balance of interest and the benefits you would have to give to the employees, the Works Council can really be painful in this regard, and that consultation procedure can take, as I said, many months, and you may have to get courts involved or so-called conciliation board involved, and that's costly and as I said, would use up quite a few months before you can then actually implement your restructuring plans.
So Hans, that's interesting. And I mean, what happens if you inform the Works Council about the transaction, and then the Works Council asks, okay, but what are the plans afterwards? Or don't they have a right to ask things?
Yeah, did you say you don't have any plans?
Okay.
The straightforward answer.
That would be a problem in the Netherlands. I mean, yeah, in the consultation process for transaction, then the only main thing that the Works Council will want to know, okay, well, could you want to transfer the shares, but what are the consequences for the employees? And then normally we would say that there aren't any direct consequences of the transaction, or there aren't any direct immediate consequences of the transaction. And normally you are able to maintain that. But if you already know that you're immediately going to integrate both companies, or you're going to restructure, or there is a 2P situation, then it would be difficult to, not to immediately request their advice or to guarantee that nothing happens. So that's a balance.
Yeah, I was sort of thinking of along the same lines in terms of, the sort of different processes. So where you've got redundancies and you're doing collective consultation, the point about timing and when you actually need to start informing and consulting around that is the point at which you kind of, you've got plans, you're thinking about proposals. And then 2P as well, when you're doing the kind of 2P prescribed information about the measures that are envisaged. And it's all very uncomfortable if you're obviously trying to sort of keep things in their boxes so that you can get the transaction through and then focus more on the kind of post-transaction issues. So it's really interesting about the kind of strategy and just needing to kind of talk through the options that are available to clients.
Yeah, and I think that if you are aware of the obligation and if you are aware of timing specifically, then it doesn't have to be a problem, right? So a lot of clients are a little bit reluctant to get the Works Council involved because they are fearing that it will hold up things. But if you are aware of it and you give their influence, they have the legal right to, then it's my experience that it can go very smoothly.
Thank you both. I think that brings us to the end of our episode today, but if any of our listeners have any questions or comments on work councils, either in the context of corporate transactions or more widely, please do get in touch with your Meritas contact firm. We'd be really happy to continue the discussions with you. And if you would like any more information about Meritas, you can obtain this via the website meritas.org. That just leaves me to thank Hans and Annette for joining me today, and we hope you'll tune in next time. Bye for now.